We're going to talk today about the nuclear verdict threats that you face. Well, back in the day, there were several thoughts in terms of dealing with the nuclear threats, and here's one way.
Be sure and remember what Bert the Turtle just did, friends, because every one of us must remember to do the same thing. That's what this film is all about. Duck and cover. That's why these children are practicing to duck and cover just as you do in your school. We all know the atomic bomb is very dangerous. Since it may be used against us, we must get ready for it, just as we are ready for many other dangers that are around us all the time.
Well, when it comes to nuclear verdicts, duck and cover is not an option. We need to be proactive. In today's session, we'll talk about denuclearizing. To avoid, eliminate, or at least to limit your exposure to any potential verdict that you have out there, what you can do and how you can do it. And we're going to start off by one of the key findings, initial findings of the ATA study. And Rebecca Brewster will fill us in terms of the importance of complying with FMCSA regulations.
Well, certainly one of the key takeaways from the qualitative analysis is, as a minimum, motor carriers should adhere to the federal motor carrier safety regs. That should be the baseline that you start from. And we all want to do better than the minimum. But what we found is when there were deviations from that, things like where the driver had a hours of service or logbook issue, where there was a driver history file issue, where there was a controlled substance involved. These 5 items here, or factors involved in the crash, in our database, 100% of the time led to a verdict in favor of the plaintiff. So things you really want to be aware of. Even if sleep or driver fatigue was involved, almost 92% of the verdicts went in favor of the plaintiff. So again, another data point in evaluating your risk assessment for trying to mediate or go into court.
Complying with FMCSA regulations, that sounds like a given, but make sure. Because if you don't, those are the type of things that will be the fundamentals that the plaintiff attorney will grasp upon and use as the fuel, the accelerator for a nuclear verdict. Under the reptile theory, presenting the jury with the argument that, hey, these folks don't even comply with the industry regulations, and thus, in order to get them in line, you need to award a strong and powerful, big verdict against them. Well, that's one of the areas to look at, but what else do you need? Now, when you have the time before the accident occurred, Nick Sager of Century Insurance tells us what they look at and gives you the ideas of what are the key elements in terms of making sure they're in order before the accident occurs to denuclearize that potential verdict.
There's a number of things, and I'll list a few here for you, but we definitely keep an eye on the FMCSA scores, and if you have poor scores or inconsistent ones, that's typically not a great thing. We look at your drivers and your driver hiring qualifications, and even if you have driver hiring qualifications or standards and you're not following those, that can be something that plaintiff attorneys can dig out in cases. We look at your safety standards and your safety practices. We have our own safety professionals that can get in and dig in on that. So those are things we look at on the underwriting side as well.
So what are the key things that the insurance company focuses in on, things that you can address ahead of time as part of denuclearizing any potential verdict against you?
The ones that we look at, I think the closest, drivers, because that's honest, that's who's behind the wheel, and vehicle maintenance as well. We think that's a key aspect in determining, what might cause a nuclear verdict or even more crashes.
And while you're getting your house in order, denuclearize by addressing those issues that came up with that mock jury we saw the other day. I think this is going to be one of the biggest, most fertile areas that plaintiff attorneys are going to try to exploit. The data that comes off of your truck and what you do with it, how you use it, and the positive use you use for it or fail to use for it in terms of driver behavior to get them to come around. Make sure that you have addressed this situation, looked at what you have, and then make sure you do something with it. I talked to Mark Shedler of J.J. Keller, one of the senior editors, and he tells us from his experience in trucking before he came to J.J. Keller what he has seen and what needs to be done with regard to this data.
When you start venturing into electronic logging devices and telematics off the engine, that's where the data fire hose gets going. This is where you can proactively see if a driver's logging illegally, detect falsification, driving too close, speeding, and things like that.
Okay, you're getting this information. How do you handle it? What do you do to approach it in terms of protecting yourself and denuclearizing the potential of a nuclear verdict that can arise from it?
They have to identify the universe of data. They have to dig into the potential sources and understand all of the data that's coming in or that they could literally be held accountable for.
Step one, find out what you got. Make sure you know what data is being generated from and coming off of that truck.
It's really crucial that the safety leader knows the universe of data generated by the telematics, the dash cam, ELDs. Once that's established, then the safety manager can look at the ones most associated with accident causing behavior, and that happens through the root cause analysis I referenced.
The use of this data for conforming driver behavior, well, it'll help you in court, but perhaps more importantly, it can keep you out of that accident, out of court in the first place.
It really provides the most effective means for accident reduction. You identify the causal behavior, you have the data that indicates the occurrence, and then you apply this to your progressive discipline training and counseling program, and you can show this as the bedrock of your program in case you're challenged in litigation.
And as we saw in the mock trial, it's one thing to have the data, it's another thing to analyze the data, but the key thing is to do something with it with regard to that driver behavior.
And the point is to have a progressive discipline policy that is understood by everyone involved and they follow it consistently.
So many things in today's world, one of the key things is to have a means of data management, to be able to curate that data and present it in a way that you can do something with it.
I don't know how fleets today can manage the fire hose of data effectively without a good dashboard and alert system that takes in all of the data from all the sources we talked about, the universe of data. My opinion, you have to use some sort of dashboard system with a filtering and prioritization process and a coaching queue in order to get to these in a timely enough manner that it shows that you're being one of the responsible carriers out there.
Denuclearize the potential verdict with regard to data. Know what you have, use it effectively, have an effective discipline policy so that you can conform that driver behavior to what it should be, because that was the message from that jury and that was the basis of the punitive damages. Denuclearize. Something you can do now before that accident occurs. If you've heard me speak before, now's the time for you to go out and get your cup of coffee, because this is the same sermon I've given in the past. Prepare now for that accident. Have an accident response plan. Know who's going to get the information, respond, who your professionals are. One of the key things that's often overlooked is who's going to take the phone call, because that person can be a vital piece of evidence, vital witness in any of these proceedings. They take down what the driver tells them. Well, if that is incorrect or it is problematic, you're stuck with that the rest of the case. Make sure whomever takes the call knows their importance, knows the necessity to be accurate, and knows the responsibilities they have so they do it accurately. When that call comes in, look, again, I've said this before, we have an advantage that none of those folks who post these nuclear verdicts online have. We have the advantage of immediacy. And if we don't get out there, if we don't get after that accident right away, we will have squandered our greatest of assets. Be ready, be prepared, act immediately. Get out there and do the investigation. Train your drivers. Make sure they have cameras and know to take pictures, what to take pictures of, and what not to take pictures of. Don't take pictures of injured individuals. I mean, be respectful to them the same way that you would want them to be respectful to your family members. And the important thing when I go out and talk to drivers meetings, about every other Saturday morning back pre-pandemic, somewhere in a firehouse with, fried food, which gave me a good excuse to eat it. The key thing that I tried to get across to the drivers, if they didn't remember anything else after the accident, is to be quiet. You can talk yourself into trouble. You can't talk yourself out of trouble. There's a difference between a defense and an excuse. You've probably heard them all before from me, but for those of you that haven't. Hey, if it would be of assistance, shoot me an email. I've developed a set of accident response documents. They're in Word format so that you can change them to fit your particular company. But they include an accident response plan, the documents to preserve after the accident, instructions for your dispatcher or whoever takes the call to talk the driver through it, photographs to take on that scene, a form for sign off by somebody who claims that they're not hurt. All those are available to you. Shoot me an email, glad to send them to you. You can change them in Word format. Now, one of the other important things is to make sure that you have responded to that accident and get somebody involved in a serious accident early. Not just professionals, but an attorney. Larry Harlow tells us the importance of this from the claim perspective.
More now than anything, you have to have a very early recognition of the exposure that you're dealing with because of this rise in these verdicts. That means that maybe you need to do a little bit more investigation. We involve experts and reconstruction experts earlier in the life of the claim. And in fact, oftentimes hiring counsel early in the case, simply because there are so many things that we have to cover to protect our policyholders against these large verdicts.
And in these serious accidents, the ones that can give rise to these nuclear verdicts, when do you need to do this?
We're retaining counsel while the vehicles are still on the scene oftentimes, right, especially in those cases that clearly have the potential for a large verdict or a large settlement.
And the qualifications of that counsel you retain? Well, I'll let Larry tell you.
Well, I think one is certainly involving counsel that works with transportation accounts or works with motor carriers. But it's important. It's imperative because one of the things that I think we've come to realize is that not only do you have to have an attorney that is professional and in terms of their handling of trucking claims, but you also have to have an attorney that recognizes the pitfalls and the strategies that a plaintiff attorney now uses as it comes to prosecuting a case against a trucking company. You can't use the same old theories that you used 25 years ago. You have to be up to date.
I'm just saying that soak in. What Larry says is something that I feel strongly about and I think is key advice to you and your companies. You need counsel out there, and there's many of them that fit this bill, who are qualified in experience, qualified in transportation, can identify the issues, know when there's a problem, and conversely, know when you're in good shape and how to present evidence to that degree. The other thing is somebody who has trial experience. Would you want a doctor who's never been through that particular operation to operate on you or your family? You need to have an experience of going through the experience of trial. It's not just knowing the rules of evidence. If that was the case, everybody that passes the bar exam would qualify. There's a lot more to it. There's logistics. There's persuasion. There is dealing with the judge, the jury, the process of it. There's a presence. It is a lot of components, and you don't get that by watching videos or going to seminars. You get it by doing it. One case at a time. Bob Tyson and I were talking about that, some of the clips you didn't see, about how few of us are out there who are still trying cases. Because one of the key things is trying a case and doing evidence is a lot like putting these videos together. You need to consider what are the key parts, what do I want to show, and how do I want to do it. And you'll hear me talk later on in terms of the first thing I do in a case is to write my closing argument. Because I want to know what am I doing right now, what's the evidence I have, and more importantly, what aspirational is the evidence I'd want to get and lead myself through the course of discovery so that I can present that best closing argument, update it, feed it as I go along. And in order to get that vision, you got to have the experience to do it. Again, please don't take this as self-serving. There's a lot of good attorneys out there, excellent attorneys who fit that bill. But just because the attorney sent to you by your insurance company, don't assume that they've got either the background in transportation or the background in trial work. And, people say, well, 95, 98% of these cases are going to settle. A couple things. You're going to get the best settlement if you're in the best position and the other side thinks you're in the best position in order to take that case to trial. That is one of the key things there. And the second thing is, if it doesn't settle, you've got to be ready to go to trial. So key considerations: experience, trials, and knowledge in transportation. Somebody who knows the way around a truck, the regulations, the rules, the dynamics of an accident. End of sermon. Yeah, this is what Rachel York Colangelo says. In terms of post-accident, preparing yourself and the best thing you can do to avoid that nuclear verdict going forward from your immediate accident response to the potential for a trial in this case, and thinking about those jurors, denuclearizing it at that stage of the game.
Primarily, my advice is start thinking about your ultimate decision maker or trier of fact from the get-go. As soon as the incident occurs, you get a claim, start thinking about how you would present this case, what story you would tell to a trier of fact, whether that's a judge, a mediator, or a juror. Storylines are the only way that corporate defendants that have these sort of negative predispositions among jurors can hook a juror and get their attention to say, let me keep an open mind. Let me actually listen to what this defendant has to say. So start thinking from the beginning about developing a compelling story that's accessible, relatable to ultimately a jury. We can be proactive when we think in terms of what story are we developing, meaning through the discovery process, you can prepare to defend your own witnesses in depositions and take smarter depositions, go after the information that you think helps to tell this story, helps to give the jurors the nuggets of information that they might be most interested in. In doing that, understanding that 95% of cases never make it to a jury, you're actually putting yourself in a better settlement position ultimately, because if you get to a mediation, you've developed this very powerful case, you're going to sell that story to the mediator as well, and hopefully get the case resolved earlier and more favorably.
One of the things I do, Rachel, is when I get a case is I start off by writing my closing based upon the facts I have now, and then use that as guidance for what would be helpful to fill in the narrative as we go forward on that.
I think that's exactly the right strategy. As you said, your goal is, here's the story that I think I can tell that will be compelling, and then what are the pieces that I can go out and proactively gather to fill in and flesh out that story.
Okay, the accident occurred. We've responded. The key thing now, evaluate. Where do you stand? What are your weaknesses? What are you facing? Do you have a potential nuclear verdict, either based on the facts that you have or what we talked about the other day in terms of being the detonators, including the individuals involved, the injuries involved, or the type of accident involved?
Yeah, first and foremost, do that risk analysis before you go into court. Take that quantitative data that we've accumulated in this database and analyzed in the database and really understand, was there something operationally, safety practice, driver hiring that we could have done differently to avoid this crash? Know what you're going into before you get there.
Well, that evaluation starts with the factors ATRI gave us in their study. The nature of the people involved, nature of the injuries, nature of the accident, things along those lines. But then each accident has its own particular dynamics to it. And that's what you want to look at, as Bill Kanaski told us during the detonators, not from a question of hunches or, general thought process, but focused in using science, research, looking at those particulars in that accident.
So another reason why nuclear verdicts happen is really a misassessment, bad assessment choices early, and a lot of hunches about what a case is actually worth, rather than putting the time, energy, and yes, money into jury science to figure out what the case is actually worth.
Well, just as early evaluation is a key element of denuclearizing the potential of any given accident or case, doing something about it is just as important, if not more crucial. Because take a look at it. Is this a case in which you want to try to get it resolved early on, before it gets momentum and before you start to build up those costs and attorney fees?
Mediations, we probably do more mediations now. And I think more importantly, we probably do mediations earlier on in the process than we did in the past. We're not waiting for the court order mediation. We're voluntarily setting one, especially in those cases where we see a potentially large exposure case. And even in a case where we feel that liability is very favorable to our policyholder, we're moving forward with that early mediation simply to try and resolve that case earlier on, because as we know, the longer the case goes, the more expensive it becomes.
Hey, quick points here on mediation. Number one, mediation does not mean capitulation. Mediation doesn't mean you got to go there and settle it. Mediation means you have an opportunity if the other side is willing to come to or close to what you've evaluated the case, what we've just talked about over the last few minutes. And we're going to look at it from the value of, if we take this case to trial, what is the most likely outcome of that verdict on that? Not some skewed view of the nuclear verdict. But again, if we know the potential's there, that'll adjust our case. But it is the trial value, not just some market of what cases have settled for. A couple months ago, right before the pandemic, picked a jury in Philadelphia. They're getting ready to start the trial, and the plaintiff attorney is trying to get the case settled and says to me, I've settled cases like this for the amount I'm asking a number of times here. That's not the market. The market is when those 12 people come in and go through the case and make a decision. That's what the value is. And Bill Kanaski says they've come up with and have been developing a way and helping clients to present that type of value to a mediator and to be successful at mediation. Here's what Bill has to say.
Well, we have many clients that will enter a mediation with our report, going to the mediator saying, hey, we hired people with PhDs in behavioral science. Here's the sample that they recruited. Here's what we showed them. Here are the results, meaning this is roughly a $5 to $8 million case. It's not the $55 million case that they're demanding, and we have scientific proof. And that has worked very, very often.
Well, doing the evaluation early on, the focus group, so that you can use it at mediation, and more importantly, so that you can change what you do or look at your strategy as you go forward, as opposed to waiting right before trial where you are limited in what you can do about it. Use that data early. That's creative and innovative. One of the findings of the ATA study was that the plaintiff's bar is far more innovative and creative than the folks on the defense side. Well, this is what Bob Tyson had to say when I put that to him.
It's a great question. So I've asked my lawyers this. I've asked 150 of them since Zoom, in the last 6 months. But I've also asked them when we've had our big gatherings. I've said, who here believes that plaintiffs' lawyers are born more creative than you?
Yeah.
No one raises their hands. And I'm like, okay. So what happened?
Yeah.
What happened? Why are they more creative than you are?
Exactly. We need to take those things that we talked about in terms of the detonators and the other issues here and look at not just as a problem, but what can we do about them? Well, let's start with one of the issues we talked about early on in terms of a potential detonator for a verdict.
Well, like in real estate, location, location, location.
Thank you, Rebecca. Geography is one of the detonators we talked about and is one of the areas we need to be both creative and aggressive to avoid being dragged into these plaintiff-friendly jurisdictions for the entirety of the claim that potentially could result in a nuclear verdict. How do we do this? Couple ways. Number one, in many states, such as Pennsylvania, where the first lawsuit is brought, that county keeps the case. That's where it's heard. So in a case in which we have an argument on liability and we've suffered damages, property damage, cargo damage, we'll sue the other person first. And we'll do it in a county that is less plaintiff friendly, usually the county where the accident occurred, particularly if it's in a rural area. Well, that locks the case in there, number one. Number two, it gives us a jump on discovery. We're able to get going before that plaintiff attorney does. An example of that, remember that video you saw, probably seems like 2 weeks ago, back in the session in terms of video, the accident at that intersection? Well, we sued that claimant's estate first. We then were able to go to mediation, get the case resolved before suit was ever filed. The other way in order to address this is many times we're dragged into these plaintiffs' jurisdictions based upon the theory that, well, we're a trucking company. You do business there. You do business everywhere. And under that theory, the belief or the argument is they can sue us just about anywhere. Well, I turn to Kurt Ruhe, Vice President and General Counsel of Crete Carrier, in terms of how he addresses that and what he has found in research from some relatively recent Supreme Court cases that can help us avoid that.
So the kind of takeaways I have are motor carriers shouldn't overlook jurisdiction as a tool to fight when jurisdiction in a state doesn't make sense. That kind of gut check reality that so many attorneys have that, oh, do you drive trucks in this area? Do you have a terminal in this area? Well, yeah, we have trucks and terminals in your state. Okay, well then you're just stuck. That mindset isn't necessarily the law in 2020. And so I think we can all benefit from taking a little bit closer look at that question. And we've kind of set out that framework of when to do it. If the accident doesn't take place where the case is brought and your driver's not from there, your company's not from there, it's really worth taking another look at jurisdiction. And Doug, the way I kind of put it, to make it real simple, is my former colleague Dave Brown had a handful of truisms he'd like to say, and one of them was, if it doesn't make sense, it doesn't make sense. And I think you should look at jurisdiction that way. If you're looking at a scenario where you're saying, hey, suit here doesn't make sense, then it probably doesn't make sense. Go to the case law and see if you can make an argument, because it might be worth trying.
Smart guy. Now, geography was one detonator we talked about. Another one, medical costs. Again, Rebecca reminds us of that.
There's we could do a whole separate topic on sort of what's going on in how medical costs are impacting these, and what are we seeing in phantom damages, those that are beyond the actual medical costs.
Well, as Rebecca noted, the ATRI study found that these medical costs are increasing for a number of reasons. Increase in technology, increase in malpractice premiums that they have. And probably more challenging is that in many instances, it's found that there's no uniform way in which to assess the value and use of these. So what do we run into in court? Well, they prove their damages, the amount of the damages, by having one of their doctors, one of the treating people, say that the bills are reasonable, necessary, related to the incident. Now, here's somebody who spends their time practicing medicine and probably only sees their own bills, waving their hands and anecdotally saying that they think that the bills are reasonable for what they are. Well, let's meet their doctor's anecdotal evidence head on with another doctor. Well, in this time, it's a doctor of healthcare economics, Dr. John Schneider.
I'm John Schneider. I'm a health economist, which means I research pretty much all aspects of the health industry. Health economists use data to build models and calculate the value of medical products and services. I have a small consulting company that provides a variety of economic analyses to pharmaceutical companies, medical device companies, and businesses involved in health-related litigation.
Dr. Schneider's primary work is unrelated to litigation, but what he does relates well to what we need in terms of the pricing of medical bills in these cases.
The litigation work we do fits well within the field of health economics because a big part of a health economist's daily activities is to figure out the fair market value of healthcare products and services. Billing data, which is the most commonly available data, doesn't reflect fair market value or reasonable value, so we rely on well-developed methods to calculate reasonable value in all of our work, whether it's for a pharmaceutical company or a business involved in litigation.
In response to their doctor who testifies as to the reasonableness of his own bills anecdotally, well, we present Dr. Schneider, a medical economist who works in this area and who derives his opinion from data. You know, medical bills are like car sticker prices. You know, nobody is paying the sticker price on that bill. Well, that's why Dr. Schneider, in his use of the data, is key in conveying this to a jury in terms of what the actual reasonable cost is.
The main problem that we're trying to address is this. In most cases, past medical expenses are based on charges, which nobody pays and don't reflect reasonable value. Future medical expenses are typically even further from reasonable value, based on rough estimates from life care planners or calls to medical facilities, where the same billing rates are read from a fee schedule. But these rates don't represent fair market value. Nobody pays these rates. In economics, fair market value or reasonable value is based on the prices at which buyers and sellers transact. Starbucks can offer a cup of coffee for $100, but nobody would buy it. Is that coffee still worth $100 if nobody will pay that much for it?
Okay, Dr. Schneider has told us the what and the why. Now he'll give us the how.
Calculating fair market or reasonable value varies depending on the type of medical expense. For outpatient expenses, such as doctor visits and prescription drugs, we rely on commonly used benchmarking data specific to the geographic area in question. For hospital expenses, we rely on patients' actual bills, but we remove the high markups from these amounts, which can sometimes be as much as 300%. We use financial data from the hospital where the patient was treated. We then add back in a market-based profit margin. There are some other specific calculations that may be necessary, but those are the main approaches. The result are amounts that are much more reflective of fair market or reasonable value.
The result is those medical bills that are used to inflate the nuclear verdict, well, they're deflated, denuclearized, by looking at the underlying data and presenting qualified evidence, not anecdotal stories or beliefs in terms of the reasonableness of somebody's own bills that they have an interest in.
We've been doing this type of work for more than 10 years. In most cases, fair market, reasonable calculations result in amounts that can be 40 to 70% less than the charges shown on hospital bills and life care plans. And it's also useful to point out that no health economist would be surprised by these differences. We see it every day when working with medical expenses based on charges.
You know, that evidence, denuclearizing the medical cost, is vital in today's environment. You know, Dr. Schneider has analyzed a number of cases for me that has been useful in terms of both mediation, avoiding that nuclear settlement by undermining what the plaintiffs assume is going to be the basis of any settlement, their medical bill amounts that have been greatly inflated in order to inflate their nuclear settlement or their nuclear verdict. And even more importantly, when we go to trial. You know, that TBI case I told you about that I had the trial about a year or so ago? Well, Dr. Schneider testified in that case in terms of what the past and future medical bill reasonable amount was. And it was very beneficial in terms of our successful outcome in that case. But any trial has to be the end product, the end vision of what we have in these cases with those medical bills or geography or otherwise, because we've got to prepare to take it the whole way. That's how we will get the best outcome in the case. And we've got to be prepared to make sure that the plaintiffs know that they're in it for a fight.
It's a fight for justice. It is a fight.
As you've heard the other day, the one of the main detonators in any nuclear verdict is where anger is elicited from the jury. Well, what we want to do to start off, case going to trial, let's defuse that, denuclearize it by finding out and determining where is the source and what can we do to neutralize it.
You have to stop and say, what is going to get a jury angry about your case? What's going to get them angry? So your first task, and clients can help with this, defense lawyers can help with this, you need to just establish a list, like let go of it. If we're so defensive, we're defense lawyers. Everyone wants to defend our actions. I get it. But first you need to step back and be a human being and say, what am I worried about? in this case. Right. And just say it, just let it out, like get it out, because that's what the plaintiff's going to focus on. Like, I don't really think my driver did anything wrong, but gosh, he had these 2 prior accidents. And if that comes in, stop going to explain it, own it, and say, yeah, this is the problem. He had 2 prior accidents and there was no reprimand and there is no company, book, there is no company training, whatever it might be. It has nothing to do with what anything our experts say. It has to do with anger.
With anger being the driving force in many of these nuclear verdicts, if not all of them, well, it is key to identify what is the potential source of anger so that we can denuclearize it. And you, as the folks who know the drivers, the participants, and the information in the background, can play a key role in that. And once we identify it, we either look for a way to defend it, or if it's a situation where we, have to address it and own up to it, then we take responsibility for it. Because it is the failure to take that responsibility that not only inflames and angers the jury, but is what the plaintiffs are counting on and looking to use against us.
You have to own it. And the other thing is, everyone feels like they're giving something up. We're defense lawyers. We want defense verdicts. That's what we want. That's all we want. So I'm not giving anything up. The only reason we would be accepting responsibility and partial or full liability is because there's not that there's no way around it. We've made an educated decision based upon input from our client that, all we got on video. We went through a red light, or we have it on video. My driver fell asleep, So we're not giving anything up. We're just owning it, and we're beating them to it because they have come up with a new way to try cases where they are assuming we're not going to accept responsibility for anything. And quite frankly, we walk into the trap every single day in courtrooms across America, and they're thrilled about it.
Okay, we've prepared for trial by identifying the anger points and working to denuclearize them, as well as looking at what are the facts or what are the situations that we need to take responsibility for and accepting it. Well, one of the other key things, and I think this was brought out by, and hopefully in terms of the being able to eavesdrop on those jurors' perspectives, is the need to bring across and to humanize our clients. Not just the individuals, but the companies as well.
Both sides said that when a verdict goes in favor of the defense, it is often because the jury understands how critical the trucking industry is, that particular trucking fleet is to their community, and how that truck driver is a member of their community, really humanizing the truck driver and what they do.
Well, as Rebecca told us the findings of the ATA study, Bob Tyson tells us what he found when he researched nuclear verdicts in doing his book and reviewing the transcripts of those cases.
One of the patterns is when you're done reading the closing arguments, and the trial went for a month, 2 months, however long it went. When you're done reading the closing, you have a really good feeling for who that plaintiff is. Like, that feeling. They do a recap of where they were born and what their family life was like. And this could be like a 50-year-old woman. And that she played sports when she was younger and she was a strong girl and became a mature go-getter woman. And then on the defense, almost bar none, when you're done reading the closing argument in a nuclear verdict, you know nothing about the defendant. Nothing. Zero.
Humanization. Rebecca Brewster tells us in the ATA study that they did interviews with both plaintiff and defense attorneys, and everyone realized it is a key, vital element in achieving the best verdict for the truck driver and the trucking company.
Well, again, and this goes to our point earlier about humanizing, that's a noticeable difference. The defense side recognized in themselves, but the plaintiffs also pointed this out, that often the defense will follow on logical arguments. This is how mechanically a truck operates. This is, brake stopping distance, whatever the case may be. Whereas on the plaintiff side, they often will appeal to emotion, which appeals to all of us. And so, for instance, if there's a crash that involves children, they'll bring in a sibling and put them on the stand and talk about, my brother's in a wheelchair now. So it really appeals to the jury, to their emotional side. And we need to recognize and do a better job of doing that on the defense side. So things like saying, this truck driver has been a little league coach for 30 years in your community. Everybody knows him. That type of humanizing of the defense side is needed.
Well, the best source of that information is you, the client, who know the drivers, the safety director, the company story.
So you guys need to help us. You clients need to help us. Okay. Your focus has always been on the plaintiff. What kind of witness impression does it make? You have to help us. You should be telling us, hey, I met with the insured, because you had it a year before litigation, or they work for you. You're the corporation, right? You're the trucking company. They work for you. Bob, I know this driver. Doug, I know this driver. Comes from a good family. He cares. He shows up to work every time. That's what we need to know.
The humanizing, it doesn't stop with the driver or the safety director.
An important piece going in, if you're going to go take this to trial, helping the jury understand this is a 3-generation business that's been supporting this community for years, been providing jobs for this community, good paying jobs for this community. Tapping into that, look what happened during the pandemic. These were the people who kept your store shelves stocked. I mean, it's just, I think there's a great opportunity for us, but helping the jury understand how valuable these men and women are who drive trucks. They're not out there to harm anyone. They want to get home at the end of the day as well.
Humanizing the company, it's just as crucial.
I don't care how big it is. I don't care if it's a big governmental entity. You need to tell a human story. There has to be a face or multiple faces to the client.
Humanization of the driver and the company, it becomes even more important in this reptile theory era.
Beyond the facts of the case, we know that plaintiff's counsel is going to want to broaden the focus to this sort of conduct of the defendant, how it's affecting the community at large. Well, we can do the flip side of that. We can tell the company's story and point out, highlight some of the great things that the company does for the community, what services it provides, and humanize by presenting witnesses that jurors can relate to, telling their story. So it's a lot about being proactive and establishing that broader framework within which then the jurors can evaluate the specific facts of the case.
Humanizing the witness is a key way to diffuse that anger that the jury may have. But another way to denuclearize is your selection as to who that person is in the first place, the witness you're going to present as the face of the company. Here's Rachel's thoughts.
In trucking, often the jurors are going to want to hear from someone who's directly involved in establishing safety policies, training. Like I said, someone with boots on the ground who's actually dealing with these policies and implementing them. Someone who can speak to, yes, I know this driver was well trained and I can attest to all of that training. I can attest to the supervision. So they most often want to hear from someone with direct knowledge of the situation that arose to the lawsuit.
Important to make that person as well as the driver involved, to humanize them as well as the company?
Absolutely. As anything that we can do to humanize the company, we should. And I know that probably your viewers are well aware of that. But bringing someone who's not necessarily a C-suite executive can go a long way in doing that. Because, for example, a supervisor, or the safety director might seem more accessible, more relatable to the average jury than a corporate executive.
Throughout these sessions, we've talked about things that impact individual cases or individual companies. But there's an important factor that is a macro consideration, one that the ATA is focusing on in order to help our entire industry.
There's been one in particular topic as I traveled across the country and as I've given these virtual presentations that's most passionate for me, and that's tort legal reform. We elevated this to Tier 1 through the Strategic Priorities Committee last MC&E over in San Diego. And I've kind of carried that torch as theme of my chairmanship throughout the year to emphasize the importance of not only the American Trucking Associations, but the entire federation to continue on with this conversation and continue on with this effort. We know it's not going to be a one silver bullet and all things are fixed. We know it's not going to be a 6-month or 1 year long project and it's over and done with. It's going to be a long, drawn out affair. It's going to take a lot of people with a lot of efforts across the country. There's a lot of state issues going on. There's a lot of federal issues going on. And it's going to take all of us to continue the effort 5, 10 years or more into the future. It's taken us that long to get to the point where we're at now.
Well, I hope you found this series that we've done helpful, useful, in a practical way to identify the threats, to see what the detonators, potential detonators are, what the impacts on juries are, and then how you can denuclearize to avoid or at least to limit the potential exposure you have to a nuclear verdict. But I want to end on some comments by Randy Gilliot in terms of what we need to do going forward so that this type of process, this thought, this sharing, this is not an end, but a beginning or at least a continuation.
But the plaintiff industry is going around promoting the idea of the verdicts in the large figures, and they actually, quite frankly, are sharing information on their success stories. That's something that they do exceptionally well that we are not as an industry and as insurance and defense attorneys are not sharing our successes in defending some of these claims nearly as much as what the plaintiff attorneys are sharing their success stories amongst themselves. So a particular verdict, an outrageous verdict that may come out of Louisiana or Georgia or Texas, for instance, now all of a sudden an attorney in Pennsylvania is using that information, that thought process on how that verdict came about, and using it to his benefit in the plaintiff world in Pennsylvania. They share this information almost to the point of laughing at us. It's offensive. It's offensive. We need to do a better job.
Becca and Randy have talked about this need to share in comparison to what the plaintiffs already do. Let's go forward and do it. You know, from my perspective, attached is my email address. If I can help you with any information, let me know. I'm trying to generate and doing a lot of these interviews and have posted a number on both YouTube and in the podcast. Please take advantage of them. Let me know if you have any thoughts or ideas of topics we want to research. So thank you again for joining us. We appreciate very much your attendance here and look forward to getting together in person next year. Because that's one of the best aspects of this conference, the fellowship, the sharing, the seeing old friends and being able to spend time together. Well, listen, until then, thank you, take care, and stay safe.